Even as there is massive outcry, it's important to break down exactly why this technical relief has been granted to Sengar, who, by the way, is convicted and remains convicted. This isn't, of course, a matter on his guilt, but it is about the length of the sentence. So why did the court grant this relief to Sengar? Let's break down this order for you. The court has now ruled that Sengar cannot be considered a public servant as was done when his sentencing was originally granted by the trial court. So aggravated sexual assault section doesn't apply to him. So he doesn't meet the criteria for this aggravated assault, and the higher, more stringent section of the POCSO does not apply to him as far as sentencing is concerned. He has already spent nearly 7 years and 5 months in jail, which exceeds POCSO's pre-2019 minimum term, which is why the court was then inclined to suspend his sentence. The bench suspended his sentence pending an appeal in the case. But it is important to note here that these are related only to the sentence and the suspension of the sentence, and does not really determine guilt or innocence otherwise. Let's also go across to my colleague Aman Sharma, who's joining us. You know, the only sigh of relief right now, Aman, for the family or even for those who are fighting for justice for the victim in this case is that actually he's not going to walk out immediately. He is serving 10 years in the case where he was convicted of the custodial death of the very victim's father.
Well, absolutely. He's not going to step out of jail as we speak, but he can always use this particular High Court judgment, which has given him relief by suspending the sentence, to make a case in the other case as well. Will that succeed or not, we don't know. But still, I think in this case, Shivani, the court order is a body blow to the case, because effectively it means that if Section 5C of the POCSO Act is removed from this particular case, in which he was convicted by the trial court for a life term, his sentence is practically over. He can walk free, at least in this case, because 7 years is the maximum sentence that can be held against him. Now, the big question is that was the CBI not able to convince the court that Section 5C will apply, because he's been convicted in that case by the trial court. The court is very clearly saying, the Delhi High Court, that Kuldeep Singh Sengar as an MLA does not fall within the definition of a public servant or somebody who has a trust or authority. This is the same premise on which the lower court had convicted him. So it's a complete U-turn, and the Delhi High Court, in a way, the case is now over, because the Delhi High Court has ruled you can't convict him under Section 5C. This means the CBI or the victim's family now will have to go to the Supreme Court to challenge this particular judgment of the High Court, saying that no, Section 5C must apply in this particular case. Kuldeep Sengar has also raised grave doubts over the victim being a minor or not. Sengar's case, even in trial court, was this, that the victim was not a minor at the time of offence, so POCSO Act does not apply at all. That the court has not commented upon so far, the High Court, but he could be using this argument even in the other cases that he is facing. So time will tell if the High Court gives him further relief even in the custodial death case. But one thing is very important, that the victim is saying that she is facing real threat to her life. And this is something that the court has also gone into, saying that Sengar can't be kept in jail forever. If the victim keeps saying her life is under danger, it's the job of the CRPF to protect her. But the fact is that the victim's father, victim's 2 aunts and a lawyer have died during the course of this case, and she claims that Mr. Sengar is behind all of that.
Yes, and as far as the father's custodial death is concerned, Sengar is indeed convicted in that case. It remains to be seen if we can use this relief in that case, because the sections would be completely different. But for the benefit of our viewers, Aman, just elaborating on this technicality on which Mr. Sengar has been let off now. He has served 7 years. The court feels that's the minimum sentence that should be applied to him, and he has already served it. So the aggravated sexual assault, penetrative sexual assault, is considered to be admitted as per law if a public servant or a police officer commits that act within the limits of a police station, or a member of the armed forces or security forces, or a hospital staff or jail staff, and it attracts a minimum punishment of 20 years, can extend to life sentence, which is the section that was applied to Sengar originally in the trial court order. But now the higher court feels that this section doesn't apply to him. Many people feeling very aggrieved, Aman, on these technicalities on which he has come out.
Well, absolutely, Shivani. And if I read out from the court judgment, as you just were, the court ruled that Mr. Sengar could not be categorized as a public servant for the purposes of Section 5C of the POCSO Act, or even Section 376 2B of the Indian Penal Code, which stands for rape. The trial court had earlier convicted Sengar for aggravated penetrative sexual assault on the ground that he fell within the definition of a public servant. But the POCSO Act does not define who a public servant is. So the Delhi High Court in its viewpoint is saying that you can't call an MLA as a public servant. He's only an elected representative. You can't term him as a public servant. So I think it's the question of how you see this particular definition. Maybe it's a lacuna in the law, but Mr. Sengar is taking advantage of the same, and the Delhi High Court seems to agree with Mr. Sengar's point of view that he is not a public servant. He's no longer an MLA as well, but because he's been in jail. But will that help him in the other case where he is convicted for the custodial death of the father of the victim, because that custodial death also happened in a police station? So will I am told by Mr. Sengar's lawyer that they will be challenging also, so asking for a suspension of sentence, even in that case, citing that the evidence against Mr. Sengar is too far-fetched in that case as well.
All right. Two cases, obviously, the nature of the two cases, one being a POXO case, one being a custodial torture death case, are different. But clearly, it's clear that this former BJP leader is on a crusade to get his sentences either reversed or put in abeyance. My colleague Ananya Bhatnagar will be getting more on this legally. But first, listen into this conversation that he had with activists who are fighting for the victim's life and honor.
Yogita, what is the plan ahead? It's a judgment that is coming from the Delhi High Court yesterday. First of all, how do you feel about this judgment? What are your initial reactions?
I feel disgusted. I feel ashamed that we are in this era where we are trying to say women empowerment, feminism and big talks on international platform. But this is a reality. A rapist, convicted rapist gets bail, or you can say the punishment goes to, like only few years and he's out. I mean, he'll be out soon, not in this case, but other cases are still on. But I'm sure the kind of sign I can see, he'll be out in no time and he'll be repeating the same crime, might be. This is a very severe situation. We might say that justice prevailed in this country, but unfortunately justice is delivered on the basis of power, money and all those bases. I don't think so we have justice in this country.
My colleague Ananya is also joining us. So Ananya, the big question in everyone's mind is that even as the victims' lawyers may be going to the Supreme Court against this, will Sengar be able to use this relief, which was regarding the technicality of the POXO sections, in the other case, which is he is also serving a 10-year sentence?
Well, absolutely not, because the other case is with regard to a murder and those accident cases, and hence the POXO case would not actually really affect it. And also, Shivani, one thing that is for sure is that Kuldeep Singh is not coming out because he's already serving a sentence in yet another case. Hence, it's a null effect judgment, though. It's a judgment in the favor of Kuldeep Singh Sengar. Definitely it will be used to claim parity in the other cases as well. But how much of it would it be entertained by the other courts is something that we'll have to wait and watch for, because suspension of sentence is kind of a mechanical relief that is usually granted to anybody. And it's only in rare cases that, this relief is actually denied. But at this juncture, this is a case that had, garnered a lot of limelight, and it was a case that began, the state of Uttar Pradesh in Unnao, but the trial was transferred to the national capital, keeping in view that there is a cloud, there is in fact a kind of influence that Kuldeep Singh Sengar, enjoys, and hence the trial was transferred to the national capital. And the whole trial in this case was actually in camera. It happened inside the Hazari court, but very clearly at this juncture, it is in fact a judgment that has shocked many. But is though somewhere or the other legally feasible as far as the High Court is concerned. But definitely a legal challenge to the same is expected before the topmost court of the country as well.
Speaking of that, let's listen in to one of the victims' lawyers, Mehmood Paracha, speaking to the media. Let's listen in.
That because the High Court has got so much workload, it cannot decide the main appeal in time. Therefore, the convict needs to be released on bail because he's probably served a major portion of the sentence, which is 10 years or life. So therefore, he needs to be granted bail. So I would see it from the side of my failures. Despite arguing at length on the following points, I was unable to convince the honorable judges. That's I find fault in me. I was unable to convince the honorable judges that the suspension application took more time and was taking more time than the actual appeal would have taken. 52 pages of judgment for suspension of sentence. It would have taken less time to finally decide the appeal. So it is my fault that I was not able to convince the honorable judges. It is my fault that I moved an application. And under what circumstances? Before me, the convict side moved an application for taking further evidence. Faced